German company law can be tiring and is in fact pretty complicated. So in this series, we will break down the most important things to know about how to compliantly manage your German entity. Even for myself, having studied law and acting as a managing director and shareholder of various companies, it is really a lot to consider and remember. One of the basics is to know how to hold a GmbH shareholder meeting. And in German, this is called Gesellschafterversammlung. Unfortunately, you can't just send out an invite with a Zoom link and you do it the next day and that's it. There are more requirements deriving from both the law, the so-called GmbH Gesetz, and your individual entity's Articles of Association, short AOA, and a German Satzung. First of all, you need to know when you have to hold a meeting. According to the GmbH law, you need to hold at least one annual shareholder meeting. But in your individual AOAs, you can decide to hold even more than the mandatory annual one, for example, quarterly. And here's a crucial thing to know: there is a notice period. That means the invite needs to be sent out at least 1 week before the day that the shareholder meeting would take place. Possibly even longer, because your individual AOAs might foresee a longer period, like 14 days. So if you hold it earlier, it will be invalid, unless everyone agrees to waive the requirements for form and time. Depending on the requirements in your AOAs, most of the time it is enough to send the invitation via email. But the invitation also has its requirements. It needs to contain an agenda. So after you send out the invitation, every shareholder needs to be able to add items to the agenda. The agenda can only be changed until 3 days prior to the meeting, then it's fixed. So it makes sense to always include something like others at the end of an agenda, so you can discuss anything that might come up during the meeting. In some cases, the AOA can require that a quorum needs to be reached when holding the shareholder meeting. And it's actually pretty common that the requirement is set at least 75% of the voting rights or the share rights that need to be present at the shareholder meeting. If those 75% of the voting rights or the share rights do not show up, the quorum of the shareholder meeting is not reached. Then you have to record the no-show in the meeting minutes, and the shareholder meeting needs to be reconvened. Only then you can schedule and send out an invitation to another shareholder meeting. The invitation is the same as I described before, but the period is most of the time shorter, and it generally doesn't matter anymore if enough people RSVP and show up. Otherwise, it would be possible to block important decisions, and law, even German law, is not that cruel to allow that. So now finally the meeting is happening, and again, you cannot just rush in and start however you want to, but you need to follow an order. So first, you need to elect a so-called Schriftführer, which you could translate to a recording clerk. I know it sounds strange, but it's basically the one responsible for taking minutes. Then you have to record the attendees and the share capital that is attending or representing the shareholders. The protocol needs to say who's actually there, and are the persons attending also rightfully authorized to represent the shareholder, if the shareholder is a company. After recording the attendees, you need to declare if the shareholder meeting actually does have a quorum and was convened in due form and time. If you have a quorum, you can proceed with the points according to the previously sent agenda and potentially any additional points which were added by the shareholders. The person taking minutes has to write down all relevant discussion points and arguments made, especially also by whom. If the attendees decide on something, this automatically constitutes a shareholder resolution. But resolutions about items that were discussed during the meeting could also be sent out after the meeting as regular circular resolutions. At the end of the meeting, you have to declare that the shareholder meeting is officially over. Sometimes the shareholder meeting is held right at the notary if it concerns decisions which need to be notarized. For example, everything related to the transfer of shares. After the meeting, the minutes have to be sent out to all attendees who have to approve and sign the minutes. You must know, and this is really important, if you just miss one crucial step that is actually legally required, your meeting is invalid and whatever you decide in that meeting is void by law. So if you don't want to risk being personally liable for whatever you're doing based on a void resolution, you should make sure to be able to prove that you complied with all of these requirements. That is done best actually with board meeting tools like Fides, because you never know when the tables will turn and you will be happy to have a proper audit trail that you did nothing wrong. And if that all sounds too complicated to manage for you, I can recommend trying out Fides. We have developed a software that will help you with every step of the way, including compliant templates for resolutions and reminding you when to hold a shareholder meeting, or even telling you which majority you need for what activity. Let me know if you have any questions and feel free to reach out. Fides is happy to help you get through this German corporate law jungle.